Hello and welcome to Other Voices, brought to you by Peninsula Peace and Justice Center. I'm your host, Paul George. On this month's edition of Other Voices, we're going to talk about the upcoming session of the Supreme Court. The first Monday of every October starts a new session of the Supreme Court, and our original plan for this program would be to talk about what we could expect to see from the Supreme Court, the caseload coming up, especially in light of the fact that this is a court that upheld the Muslim travel ban last year, undermined the Voting Rights Act. We wanted to take a look ahead. And we thought that the nomination for the next Supreme Court Justice, Brett Kavanaugh, would have been pretty much a done deal by this time. We got surprised by that one, so we're going to talk about the Brett Kavanaugh nomination tonight as well. You betcha. And I'm really pleased to be joined by two of our local shining lights of the legal community. Directly to my right here, Judge LaDoris Cordell, retired Superior Court judge, former Palo Alto City Council member, and well-known and loved and respected community activist. LaDoris, thank you for coming back.
Thank you for inviting me.
And Dan Mayfield, a criminal defense attorney from San Jose, active member of the National Lawyers Guild. Dan, thank you for coming back. You were both here before, about a year ago, to talk about the Injustice Department of Jeff Sessions. And
right.
Total pleasure.
Now we can talk about another kind of injustice. Yes. And I might mention that both of these fine people have won multiple awards in their field and various honors. So thank you for being here with us. Let's get to the topic of the day that we can't avoid. It's the Brett Kavanaugh, and I'll just ask you both for your initial impressions. Go for it.
Well,
what are we looking at here? What are we witnessing?
Well, let me just say that the judiciary is the third branch of our government, and it is supposed to be the least dangerous. And under the current administration and the way things are headed, I believe it will become perhaps the most dangerous, which I find very sad. Mm-hmm. And if Kavanaugh, and if not Kavanaugh, I will tell you the fix is in. There will be another nominee, if he is not the one, who will be taken off the list given to Trump by the Federalist Society, and I hope we can talk a little bit about the Federalist Society. That unless this gets dragged out beyond the midterm elections, and unless the Democrats do not take more seats so that they can have a majority, at least in the House, but hopefully and probably least likely in the Senate, whomever he nominates is going to get a seat. And then you're going to have a Supreme Court that has a conservative bent and will continue to undo things that make our lives manageable and livable, and actually are going to be working against really what the public really wants, the majority of people want. And that's very dangerous.
And we are going to get deeply into precedent and how solid that is and that sort of thing. But when you mention precedents that kind of underpin our society right now, these are precedents that have been in place for a long time that may get pulled out from under us. But we'll go back to that. Dan, your first thoughts on what we're witnessing here.
So let's start with the idea of the fix, because assuming that we defeat Kavanaugh, that we know that that President Trump has a list supplied to him by the Federalist Society. So Kavanaugh's gone, a Kavanaugh clone comes in, and those people are already been vetted by the Federalist Society. We already know, how they're going to rule on various things. And I know we're going to talk about stuff that's coming up, but it's not just the issue of what's coming up this term or what's already been accepted. Remember that Kavanaugh is 52.
Right.
and whoever they bring in to replace him is also going to be 52.
Or younger.
Or younger. And they're going to sit on the Supreme Court for 30 years, maybe 40 years. And pretty much everything will come up. And just very, very, very quickly, think about how abortion in particular will come up. There's no case about abortion on the docket right now, but it comes up because a state legislature passes a law that's very restrictive. And then the decisions say, the Casey decision says, well, it can't be unduly restrictive. Well, hey, those are great words, unduly restrictive. So then you have to have a hearing about what is unduly restrictive. And then you finally get to the Supreme Court, and that you've got, at this point, probably a 6-3 vote saying, oh, well, nothing is unduly restrictive. So that's what's at stake here with this nomination. And assuming that he doesn't get nominated, whoever comes up after him.
Yeah. Okay, let's stick with the Federalist Society for a minute, because when you were mentioning that, both of you just now, there was something I heard in an interview with, I think it's Peter Klain, former high-ranking official in both the Clinton and Obama administrations, who did a radio interview the other day, and he laid out how Kavanaugh was not on the original list that was submitted by the Federalist Society. And he wasn't even on the second list. He was on the third list. And he's been really campaigning to get this job. And the suspicion is that he let somebody know, and this came out in some of the confirmation hearings, that he has a very broad view of presidential power.
Right.
And he seemed to be kind of hand-picked for what we can expect to see coming out of the Robert Mueller investigation. Maybe a subpoena of a sitting president. It's never been tested before. So your thought, have you heard that?
I'm not surprised. I mean, nothing surprises me at all about any of this, so I'm not surprised at all. But I do believe that in order to understand how we got to where we are to the Supreme Court, it is so important to understand that route. And that route started in 1982. There were disgruntled law students at the University of Chicago and at Yale who felt they did not have a safe space because they were conservatives. And at the time, law schools, and still today, basically are liberal and progressive. So they formed the Federalist Society, and the full name is the Federalist Society for Law and Public Policy Studies. Ah. That's the full name. And very quickly, it spread throughout other top law schools throughout the country. And not only did it bring, the Federalist Society bring in students, it brought in conservative law professors who saw this as an opportunity to groom law students to go on to the federal bench.
To become Brett Kavanaugh.
That's correct, to be conservatives. So the philosophy of the Federalist Society is that they are the guardians of what American society should be, which is a society that follows the letter of the law and framers' intent. So a big issue came up in 1980. So Ronald Reagan gets elected, and this is when he, together with the Federalist Society, planned to fast-track a transformation of the federal bench. So if you remember, Reagan nominated Sandra Day O'Connor during his term, Scalia, Rehnquist, who was the Chief Justice, and Bork. And the Bork nomination, as we recall, failed by a vote of 58-42. And the result was that Republicans and the Federalist Society knew they had to be more cagey. They could not have candidates, nominees like Bork, who spoke truthfully. He said exactly how he felt about issues. Mm-hmm. And so the message from all of that was he got rejected. That was a defining moment for the Federalist Society and for Republican presidents to say, oh, no, we can't have nominees speaking the way Bork did, which is speaking truthfully. So after Bork was rejected, eventually it was Anthony Kennedy who came on. Bush won, appointed Souter. Then you get to 1992, and you have the case of Planned Parenthood versus Casey, and it was a woman's right to choose. And at this time, the Supreme Court was stocked with Republican nominees, appointees. Yet, on that case, the court voted 7-2 to uphold most of Roe versus Wade. So conservatives realized at that point something went wrong, and they needed to do better vetting of the nominees. So they redoubled their efforts with respect to nominating judges. So in 2005, we get to George W. Bush, and he nominates White House counsel Harriet Miers to the Supreme Court. Well, The Federalist Society had never heard of her, and Harriet Miers was not one of them. So the Federalist Society objected and let Republicans on Capitol Hill know that they were not supportive of this. And the result was that Republicans refused to support her. And so what did she do? She withdrew her nomination. So the next nominee was Alito, and he was a darling of the Federalist Society. So the Harriet Miers affair demonstrated that the Federalist Society has to be listened to, and that it has the power to say no to a Republican president. So here comes Trump. Trump was ignorant about the Federalist Society when he campaigned for president, and the Federalist Society was ignorant of him. They didn't know anything about him other than that he has no judicial philosophy at all. Right. And what Trump knew,
or other political
that's
philosophy.
Right. But what Trump knew was that he needed votes, and he knew that the conservatives wanted the judiciary. So the result has been and is that Trump has openly and brazenly subcontracted out his presidential responsibility to appoint federal judges to the Federalist Society. So he gets his list of, as you mentioned, of judicial nominees from a man named Leonard Leo, who is the executive vice president of the Federalist Society. And he became a part of Trump's campaign. So they went to work immediately, because when Trump came on, there were 107 federal vacancies. Wow. And that's not counting vacancies on the Supreme Court. So in his first 2 years, 26 federal judges were confirmed that Trump had nominated. And so you get to Kavanaugh. He is the perfect Federalist nominee. He was a member of the Federalist Society at Yale. He worked for Bush. He was appointed to the Circuit Court, the appellate court, that's the federal appellate court, and that's the same path that Gorsuch followed. So one final thought. We talk about the Supreme Court, and it's important, but more important, I think, are the circuit courts. The circuit courts are the level just below the U.S. Supreme Court. And the Supreme Court hears very few cases, very, very few, and actually fewer as the years have gone on. But with regard to the circuit courts, they hear thousands of cases. And those circuit courts are now populated by these conservative appointees.
Wow.
Yeah.
So go ahead.
A law professor from Massachusetts, a National Lawyers Guild member named Michael Avery, wrote a very good book about the Federalist Society. And but one of the things that he points out is that they have actually done, in a whole lot of ways, what the left has not done, is that they've said to people, if you join the Federalist Society, we will then help you get a job. That will be a good thing when you go and apply for a job, that you say, I belong to the Federalist Society, and we will hook you up with a Federalist Society member at a partner at a big firm, and they will bring you in.
And clerkships.
And judicial clerkships in particular. Interesting little connections there between Kavanaugh and clerkships and the Ninth Circuit even. But they have advertised themselves as a stepping stone to getting work, getting an entry into the elite part of legal society. Just this year at their convention, John Bolton was their keynote speaker. When I was in Washington about 10 years ago, I was there for a National Lawyers Guild convention. Right around the corner was the Federalist Society convention. Justice Scalia was their keynote speaker.
The bar scene that evening must have been really interesting.
But they've done that, and that thereby pulled people in because it is a ticket to moving up. Inside a firm, inside the judiciary.
Yeah. Well, why hasn't the National Lawyers Guild established an employment program like this? But seriously, on the other side of the coin, what do Democratic presidents, what's their process look like there is no Federalist Society on the left, as Dan just pointed out.
No, there isn't. And you know, part of it is, you know, we have not paid attention. So that's, you know, now we look around and we see the situation. So what Democrats have done, and well, first of all, when Barack Obama was in, it was made clear, right? Because there's no majority in the Senate of Democrats, they made it clear, we're not going to approve your nominees.
Yeah.
We will stymie them, we'll do whatever we need to do.
Which they really showed with
Right.
Garland.
Right,
Yeah.
and then there's the filibuster. So just so we understand, normally federal judges are appointed after receiving the advice and consent of the Senate, right?
Right.
Advice and consent. And normally that meant 60 votes from the Senate, which is 3/5, in order to confirm a nominee. So the president nominates, but then they have to vote. So Democrats, and I believe it may have been in 2000, I'm not sure what year it was, decided, look, you know, given what's going on here, we're going to change the rule and say that it only requires 51 votes, but only for federal judges, not including the Supreme Court. They said we still want to do the 60 votes for Supreme Court appointees.
The filibuster.
So, so when Republicans came in and took charge, and McConnell was very clear on this, he said, you know what? And he said, you go ahead and do this, Democrats. You're going to pay the price, and maybe sooner than you think. So what did they do? They now have said, you know what? We're now only going to go with 51 votes for the Supreme Court as well. So as a result, the minority, because 51, right, there's a whole bunch that don't get to be heard and are not a part of the process. So that's what we have now.
Yeah.
So
You mentioned that Bork got 58 votes.
No,
If
no, 40.
58, 42 to 58.
Yeah.
42.
Yeah,
because he would have needed 60.
Yes.
If Brett Kavanaugh gets on, he's going to get fewer than 58 votes this time
Yeah,
around.
I mean, he only needs 51.
Yeah.
And that's where the swing are the two women in the Senate on the Republican side, who are Collins and the other from Alaska,
Murkowski.
right? So we'll see, we'll
Yeah.
see. But this is where we have come now, where the Supreme Court is doing far less law and doing far more politics.
Yeah, we're going to certainly get into that. By the way, Claire McCaskill, senator from Missouri, who might have been voting for, because she has a tough re-election, announced today that she will vote no on the Kavanaugh nomination. Yeah. And with everything going on, she specifically pointed out his position on dark money in political campaigns as why she's going to oppose him. I thought it was quite a good statement.
Yeah. Just one quick thing. Kavanaugh, 75 times as an appellate judge on the circuit court, overruled federal regulators on cases involving issues like clean air, consumer protection, net neutrality, in order to protect, in his words, American businesses from illegal activities. 75 times he has overruled government regulations of business.
That's what he's referring to as illegal activities,
Yes.
government
Regulation.
regulation on
That's
behalf
right.
of the environment, people's
That's
health.
correct.
Yeah.
Yeah. Very scary.
Let's talk about what we just heard last week, the confirmation hearings. And one of you started to hint at this about precedent and what's known as stare decisis, if I'm saying that right. Judge Cordell, you mentioned not answering questions. And that's
Yeah.
mostly what Brett Kavanaugh did, was not answer questions because it might come up before the court. As you pointed out, in his 40 years on the court, anything could come up.
It's the biggest dodge that you can possibly have. I'm not going to answer that question because it might come up. There's nothing that falls into that, or everything falls into that category, or nothing that won't come up. And he kept saying, he actually said this, which was actually not true. I'm going to use the Justice Ginsburg answer to that question. It's exactly what he said, which was not true. That's not how Justice Ginsburg answered the questions. But the fact is that all of these things will come up. They should all be on the table. And it's a real different question from saying to somebody, how will you vote on, whatever? People versus Cordell. How will you vote on that case? That's one kind of question. Another question is, tell me what your position is on such and such. So, for instance, with abortion, he kept saying it's precedent upon precedent. And I'm telling you, if we see him or whoever we see there, that's just going to be a lie, because it's going to come up on a states' rights issue. That's how it's going to come up. And just like I said before, a state will pass a law that will say doctors can only do abortions if they're admitted to the closest hospital to the abortion clinic as a full partner in that hospital with emergency room abilities, or whatever the term is.
There have in fact been laws like this passed.
And so then that will come up to the Supreme Court, and the question will be, within the realm of precedent, is that unduly restrictive on the rights of women? And that's how it'll come up, and that's how they'll just chip away at it.
What about a direct challenge to Roe v. Wade, though? How solid is Supreme Court precedent? They can overturn precedent cases, right?
Sure,
and decide a different way. There's no law that says once it's...
Well, basically there are rules that say when you have issued a decision, that's the decision. Let's talk about the Supreme Court. That's the decision that stands. So there has to be something extraordinary to overrule that, to change it. So, for example, you had Plessy versus Ferguson, which said that basically black people had no rights, and that was it. I mean, that was kind of the. And so, as times changed and mores changed in society, the court changed as well. Mm-hmm. So the danger is when you have a court that does not reflect what the public is doing. So majority of Americans support the right of a woman to choose. So if the Supreme Court just says, oh, we're just going to do away with that, there are going to be huge problems, meaning just in terms of unrest in the country. So what this court has done is kind of take it slower. So for example, 1954 Brown versus Board of Education says you cannot have segregated public education, right? And that was ahead of the times. Most of the country was not there. So what did the court do next? The court had a second Brown versus Board of Education 2, which was to say, well, when do we have to do this? Because there were complaints that nothing was happening. And the court basically backpedaled.
All deliberate speed.
With all deliberate speed, instead of saying, right now, we mean right now.
All deliberate
And
speed.
so it was really a response to most of the country not being ready to say right now. So you get this all deliberate speed. I'm not saying it's a good thing, but it's a way that laws have been enacted by way of the courts where people have been able to adapt. So yes, this court, especially if Trump gets another position on the court, which he likely will one way or the other, they may just go against however the public feels about major things. And there are going to be some huge problems, but it will be the law coming out of the Supreme Court. So we can talk later about, what can we do if you have these justices. I do want to, just a couple of quick factoids on the Supreme Court. There's nothing in the Constitution that says what the qualifications are of a justice. So Trump could nominate his daughter. He can nominate anybody he wants. There are no qualifications, no requirement that the person even be a lawyer. But of course, the check on that is always the Senate, right?
Approval,
yeah. And also, there's nothing in the Constitution that states how many Supreme Court justices there should be. So there have been 7, there have been 10, there have been 11, and now we have 9. So there's nothing. I mean, change can happen on a lot of things. FDR tried to pack the court by adding 6 at the time, right?
Because they were ruling against him.
Exactly. So, and so court packing is very, very dangerous. It's very dangerous because you end up with the courts making political decisions, really deciding how this country should be run, and that is not the role of the judiciary.
But thinking about stare decisis, look what they did with guns, right? For years and years and years, the Supreme Court said when you look at the Second Amendment, the important word there is militia. And then all of a sudden, you get a decision from the Supreme Court that says, well, what's really important here is the right to bear arms. And they're just going to ignore the whole first clause of the Second Amendment. And they just flipped it. That at 40 years of precedent, boom, gone.
Let's take off on that point for a minute and do a little crystal ball gazing. It doesn't look like any big controversial case on the docket yet for the coming year, but keeping in mind what you've both been saying is that this is going to be a conservative court for years. Everybody's been kind of focused on Roe v. Wade and the threats to that decision, with Kavanaugh waiting in the wings. What else do you see as being vulnerable?
I think gerrymandering. I think that's coming up. There are two cases working their way up, and they may be before the court in this term. One is gerrymandering contested by Democrats in one state, and I'll pull up the states in a second, and the other by Republicans. Now, what is so frightening here is Justice Roberts has written that, and it may have been in a dissent, but he has written that he opposes. So a lot of states have come up with commissions to do the setting up the lines for voting, because they don't want to leave it up to judges to do. So commissions. So Roberts opposes that, and he says they are just like a magic trick, and we shouldn't have these state commissions. So it's very interesting because Kavanaugh, if Roberts gets one more person on that court that feels as he does, then they can make unlawful the use of commissions.
Which is what we have here in California.
That's right.
The Citizens Commission, and they ended up doing a fabulous job from what I read of the experts.
Roberts doesn't like them. Kavanaugh doesn't like them.
On what basis? Isn't this states' rights? A state can...
Well, it's really interesting how they flip from states' rights to
they like states' rights when it goes their way.
But he calls it a magic trick. And so that's very scary, that Kavanaugh, if he gets the person he wants on there, then he has the votes.
Yeah.
Their argument is in that the way that they frame that is it's anti-democratic, that you're going to elect your state representatives, and then they should be drawing those lines, not a commission of the state that looks at things scientifically or whatever. So it's an interesting argument, but it doesn't look at the essence of gerrymandering, which is, well, we've all seen them, these districts that are 4 miles wide and 200 miles long.
Yeah.
That sort of thing. And
yeah, but he is determined to find that these commissions are unconstitutional. And if he gets the votes he needs, just needs 5, that's it.
Well, you both agreed quickly on that one. What else might we be looking at? Long-time precedent that we've gotten used to and come to rely on that might be at risk.
Remember that ALEC, the American Legislative Exchange Commission, has got a whole agenda of stuff coming up. But in particular, remember that
this is just in case anybody doesn't know or has forgotten. ALEC is a national organization that writes model legislation for states and then goes around and shops at the state legislatures. And so you'll find the same ALEC bill in a dozen state legislatures at any given time. Go ahead.
Right.
Well, they were the money behind the Janus decision. Janus is the dues checkoff for public unions, and they have a number of cases similar to that are coming up.
Challenging public unions?
Well, challenging any unions, challenging any dues checkoff, challenging the union's ability to raise money from its members to do political work, and how you separate political money from regular sort of union activity money. Those kinds of things. Those things are coming up, and they're coming up through the federal courts now, all over the place, all funded by ALEC. There are a couple death penalty cases that are coming up. One that's particularly interesting to me, that having to do with a person who was sentenced to death but is now completely mentally infirm, doesn't know his own name, doesn't know where he is, doesn't know what's going on, that can you apply the death penalty to somebody in that situation?
What state is that? Do you know?
Where I could
That's
look
okay.
I could look it up while we're here real quickly, but but that's actually on the docket coming up now, that particular issue.
Yeah, and I think Trump's travel ban, there may be more issues coming up
Sure,
with the travel ban.
he's going to want to strengthen it, yeah.
Is there
So-
anything on the docket this year that you've looked at that is of particular interest?
Well, I haven't had time to look at them, but I think that there is an issue regarding Trump's travel ban where barring foreign nationals from certain predominantly Muslim countries from entering the U.S. So that's another issue that's going to come up.
There's some issues about Native American sovereignty that are going to be really interesting. It's coming up in relationship to both gun ownership and the death penalty, but that depending on how it's decided in terms of Native American sovereignty, that it could, for instance, affect things like Indian casinos. It could affect even the ability of recognized tribes to have their own court system, which they have now for things below felony level, for instance. Stuff like that. Those are all coming up.
Yeah, there was a real interesting line of questioning from Senator Hirono of Hawaii. I don't know if you
Yes.
heard that part about
Yes.
Native American rights, pointing out that Kavanaugh didn't even recognize that there were Native Hawaiians in Hawaii. His ruling just kind of overlooked the fact that, so that should be interesting.
Yeah, she was very, very strong on that.
What are the outstanding, in terms of outstandingly bad decisions that we're looking at from last year that we're carrying forward? That can any of these bad things, like the undermining the Voting Rights Act, be reversed sometime in the future? Not with this court, but yeah.
You know, that's a huge one. I'm still stunned, and few things stun me anymore, about how blatantly states and then the U.S. Supreme Court are diminishing the rights of people to vote, especially people of low income and people of color. It's just so blatant to me. I find it absolutely stunning. So I believe the decision, and Roberts wrote it, was just egregious, where he gutted the part of the Voting Rights Act that required states who have a history of engaging in discrimination and voter suppression. But before they could change any of their rules or enact any kind of laws, they had to get permission from the federal government to do so. And Roberts basically said, no, we don't need that anymore because we've arrived. And it's just stunning because once that decision came out, various states just went crazy enacting all kinds of methods of voter suppression.
That's where this gerrymandering stuff is all going to
yes.
be done.
And that's where the voter suppression stuff ends up being really important, because one of the things I was looking at preparing for this was about who votes and where and how. Somebody's mic dropped. But one of the really, really interesting things is that in the 2016 election, that only 54% of black men voted. Now, why is that? That some of it certainly has to do with the kind of voter suppression that takes place in terms of doing things to stop people who are incarcerated from voting, people who have felony convictions, now, which is now down to fewer than 10 states, by the way. That's very important. But it's a concentrated use of voter suppression against certain populations.
Yeah.
So the hard part of this, though, is that the right to vote is not embodied in the Constitution. They didn't put it in. The Founding Fathers didn't put that in the Constitution. So as a result, it is left to the states and local jurisdictions to devise their own rules, which is why we have the mess we have. Yeah. I mean, clearly what needs to be done, there needs to be federal rules about elections, period, not just federal elections, but all, and they don't exist. And that's why, you get back to states that are able to enact these kinds of things, and then you rely on lawyers, good lawyers, who challenge these and then take them to the courts. But, you look at where they could eventually end up, circuit courts, mostly conservative judges, and then eventually the Supreme Court. So, I don't want to sound like there's no hope, but I almost feel that way for, I'm sure we'll talk about some things maybe that can be
Well,
done.
I wanted to talk about that right now because I do want to get to the audience for their questions and comments, but we are going to be turning to an audience full of activists here. And I think activism around the Supreme Court is not something that has really come up very often.
What does that mean? What do you mean activism around the Supreme Court? What does that really mean?
That's what I wanted to ask you.
Well,
Because when you look at the process,
FDR.
well, if you look at the process, and when we talk about activism, I'm talking about us, the regular vote. So if you look at the process, it is the president who nominates, and then you have this procedure that happens in the states. So the senators generally used to be the case. They would nominate, recommend someone from their states. So Feinstein then, and back in the day, Boxer, they would, agree, and they'd take turns on nominating, and then it would go up. Well, that's all
For somebody
changing.
who would serve on a circuit in this state.
Yeah, exactly. So, not so much now because, as I said, things have changed dramatically. So what influence, what can we do?
Right.
What we can do more than anything else is vote. It's the power of the ballot to say that we need more people than not holding positions in the Senate and in the House, because eventually all federal judges are there through the advice and consent of the Senate, not just the Supreme Court, but all federal judges. So that's what's needed. Right now, Trump has put through a record number, and I fault some of the Democrats for not standing up and kind of caving in on what's going on here. So there's this pipeline, and for, as Dan said, 30, 40 years to come, we're screwed. We really are. So we have to figure out how to play this game. So they have played the game. The Federal Society, they created the pipeline. We need that playbook, and we need to get on it now so that we are in a position to do it. So one is the pipeline issue, but the other is voting. Not enough people vote. They don't. And I'm just stunned in California, where you get, if you vote by mail-in ballot, the state even pays your postage, and people don't vote.
Yeah.
So if people feel, I don't want to, I don't have an interest in this, we have to figure out, those of us who vote and who care, how do we get people concerned enough, motivated enough to just pick up a pen and fill out a ballot and give it to the postal worker.
Yeah, put it in your mailbox out front. Do you have a definition of judicial activism, or what we can do about this?
I want to go back very quickly when you think about this, and I know it's not answering your question, but did you see did you see some of the hearings for some of the people who got nominated for the lower level judgeships? They were amazing. And I'm sorry, I don't remember the person's name, but a person gets put forward to be a federal judge, lifetime appointment. He goes in front of the Judiciary Committee, and they ask him questions, really simple questions. Can you tell me what a subpoena is? I will get back to you on that.
We saw that, yeah.
Yes.
That's
This
all
is
over
the
YouTube.
person who had never actually been in a courtroom.
Never
had
tried a case.
Right. And he's being nominated for a federal judgeship. Well, what about a grand jury? Well, I'll get back to you on that. I mean, that's the kind of people who are being put forward for these positions.
Well, not all of them, Dan. Some of them have stellar credentials. They're conservative, but I mean, good educations, done all of the right things. So that's not to say that there aren't people who are qualified, well qualified to be on the courts. Democrats, when we were in charge, we did the same thing. We looked at nominees who had stellar credentials, but who were going to be more progressive and liberal. I mean, that's the way things have gone here. But now I see it tilting so much that the courts are no longer doing law. They're doing politics.
Yeah.
And that's really more because I think of the kind of the extreme conservative bent that is now coming forward out of our circuit courts and onto the Supreme Court.
Yeah, everything's out of balance. The legislature no longer legislates and makes laws.
Well, the
You know, the
courts.
House and the Senate, but the courts do. Let's get the audience in on this. Steffi will come around with the microphone, and if you'll stand up and make it easier on our camera people, we'd appreciate
Thank you
that.
for all your smart comments. My question is about, say, California and other progressive states, which are trying to, say, protect the environment and immigrants. And these cases, you know, California's right to do that, I think, is being challenged in the courts. What do you think about states' rights to do things that we like, as opposed to states' rights to do things we don't like?
Well, the states' rights, and it's a good question, states' rights used to be anathema but especially to people of color, because that was invoked, you know, states' rights, and that way during the civil rights era, 50s, 60s. So now it's flipped. It's like progressives are embracing, and I think have to embrace states' rights to say to the Trump administration, no, you are not going to roll back these regulations we have regulating pollution, these kinds of things. It's states' rights. So now it's like, it's flipped. You know, progressives, we need to be embracing this notion, as long as we need to, of states' rights.
And the question, the federal question becomes essentially, if you're going to allow products to move across state lines, does the federal government get to decide what products are going to be and what the bottom line is? And it's particularly true about automobiles and what kind of rules there will be about mileage and amount of smog and that sort of thing. Or can a state, in particular California, where, what do we have? We have a tenth of all the cars in the country in California that can have their own rules about that. And
I saw all those cars driving down here today.
so, I mean, so that's the issue. I see it more as a political question, that it really is a matter of not some sort of legal theory that is very clear. That it's a political question about exactly how are you going to run things here in your locality. You have specific problems. Los Angeles has specific problems about smog, that because it's a basin and everything stays there in the basin. So you need specific rules for what you're going to do in that area. You know, so well, I don't know. As a general rule, that I think that the question truly is, are you creating local rules for the betterment of society, or are you creating local rules to separate people out? Are you going to create local rules for segregation? Are you going to create local rules that cause more inequality? And those are the kind of things that you can look at, I think, at the federal level and say, no, this rule is because you have a specific problem in an area.
Okay, anybody else in the audience with a question? Okay, and if you'll stand up.
Yes.
And hold it right up there.
Yes, thank you very much. With regard to voting, there are countries in the world where voting is mandatory. Everybody votes on a Sunday, everything closes, and you're obliged to vote. Could it be that California passes a law that says, in California at least, voting will be mandatory?
there's nothing to prohibit, I don't believe, California from doing that. So there's two philosophies on this. One is it's the carrot and the stick. So the stick approach is if you don't vote, you will be fined. And that's what happens in Australia, I believe. The other is to hold a carrot out and say, if you do vote, then what? I mean, there should be, maybe that's what's needed. But I think your suggestion is a good one, that California tends to set the trend oftentimes. So if the state said, you know what, we're going to change voting from Tuesday to a Sunday or a Saturday, I'm not sure, somewhere where people don't have to take off work, somehow to make it easier. And we do that here in California. It's not like we're engaging in voter suppression, not here in California, at least generally. I mean, there may be some locales that are making it difficult. But I think it's something worth thinking about how we can encourage people to exercise the vote. Because I have found trying to guilt people into doing it doesn't work. And I say to people, do you understand, for example, I say, in my own family, my great-grandmother and great-great-grandmother on my maternal side were slaves. They were slaves. So they survived all of that oppression so that, you know, I could be here, my sisters could be here. And so to not exercise the very right to vote that they were denied and they suffered for to get us here is just, it's just criminal to me. It doesn't seem to kind of get people enough. So, you know, we have to be creative, think outside the box. What is it that we need to do that gets people to fill out that ballot?
I think you're right. First, it's got to be simpler. This first Tuesday in November was from when we were an agrarian society,
Right.
and you know, there's no reason why the voting period can't be 2 weeks long or a month long. You know, and the mail-in ballots and things like that.
I want to just go back to something I mentioned before about when we were talking about voter suppression. That because, first of all, that's a very real thing about what's happening, and I'll tell you a story about it very, very quickly. But probably once a month, somebody comes into my office, and I do a lot of work cleaning up people's history, so their criminal history, and they say, I'm 60 years old and I've never voted because I committed a felony when I was 18. Now, that's not the law in California. It hasn't been the law in California since 1973. There are now 9 or 10 states, and that's it, that disenfranchise felons, and only 3 that completely disenfranchise felons. But that is a pervasive view. I committed a felony, I can't vote. That Governor Brown just signed a law that said that people who are in local jail on felonies can vote. People who, because of realignment, we have a lot of felons who are doing, in essence, local time, that those people can vote. We have to get that information out to people because they are self-censoring about their ability to vote. You know, you don't actually have to have the Republicans stopping you from voting. People are self-censoring and not going to do that. So very, very quickly, and I'm sorry because I'm taking it. I'm from Indiana. My mother is still alive, and I went with her to vote. Now this was probably 10 years ago. So I took my mom to vote along with her neighbor. We go down to the polling place, and my mom, because my brother had helped her, had an ID, Indiana state ID, because she obviously no longer drives. Her neighbor had an expired driver's license. The person working at the polling place knew that woman, looks at her driver's license and says, "Mildred, I am sorry, you can't vote. This is an expired driver's license." Knew her personally, but she couldn't vote because she had an expired driver's license, and turned her away. I saw it myself.
What a story. Jeez. I hope they weren't neighbors. Anything else in the audience here? Okay, over here.
Hi. Just a bit of information. In Ecuador, you have to vote. Well, you You don't have to vote, you have to show up at the polls. And you can draw a line through the ballot, or you can just turn it in blank. But you've got to show up, which is another way of looking
If you don't, what happens?
at, pardon me?
If you do not show up, what happens?
I think there's a fine. I'm not sure. But on the other side, about guilt tripping, when I went door to door and people said, "Oh, I never vote," I always say, "Do you like the way things are?" And they say, "No." Well, you can make a difference.
Great.
Thank you. Anything else in the audience? Let me hit you with a couple of quick questions going back to our pal Brett Kavanaugh. If he gets confirmed and gets on the court, and then the Senate finds out or has proof that there have been numerous allegations that he's lied about a number of things to the Senate. If they get proof that he was lying, like the 98% of the White House documents that they don't have, can he be impeached?
That's interesting. So the question is, will he have, under your scenario, committed a crime? And the crime would be perjury, because when you testify before
Under
the
oath.
Senate, Judiciary Committee, or even the FBI, you're under oath, and it is a crime. So to ask the question, can he be impeached? So impeachment means, can he be brought to trial? That's what that means. Now, whether or not he would actually be found guilty and then thrown out is an issue, because it's voted on by the Senate, right? Here we go, the Senate again. So, you know, I don't know if there is the political will to make that happen. And by that I mean, if there were more Democrats and progressives in, yeah, that conceivably could be on the table. But if we continue to be in the minority, it's just never going to happen.
Yeah.
But the answer is he can be impeached.
He can. The House can
what-
bring a bill of impeachment against a Supreme Court justice, just like with the president.
Yeah.
And
yeah,
I think
and-
it's
and
actually happened in the past.
They've done it to a few federal
Federal
judges.
judges, not Supreme Court, but federal.
Generally, anybody who's gotten in trouble with the Supreme Court has resigned, you know, because of whatever, the embarrassment. So,
And the other question, having to do directly with Kavanaugh, is, as I understand it, there's no, unlike every other court, there are no guidelines for the Supreme Court for when they must recuse themselves from a case.
Right.
So that if these constitutional questions from the Mueller investigation come up, like a presidential subpoena, there's nothing that would compel him to recuse himself from hearing that, even though he was just appointed by this guy.
because there's nobody above them to go to,
To
and
enforce
complain.
it, yeah.
But that's when public, you know, the public response, the public outrage, if there's enough, I think that could mean something, and it might make something like a recusal happen. But if people are kind of laid back and like, oh, well, it's not going to do any good anyway, yeah, it's not going to change things. I'm just curious as to one last thing. I know there's been some talk about having a constitutional amendment to change the lifetime requirement of federal
That was going
judges.
to be my next question. Yeah, there was just an article in a column in the New York Times yesterday, but this is something that's been an idea that's been kicking around. What I learned from yesterday's column in the Times was that no other country has lifetime appointments for such positions. So this is unique to us. So just quickly, the concept, and we've got about 3 or 4 minutes here, is that there would be some kind of set term. And the one that was proposed yesterday, this particular method, is 18 years.
Right.
And the 9 positions would be staggered so that each president presumably would have an opportunity to appoint two. And they could reappoint an existing one for another 18-year term, or bring on their own person if they got a retiree. What are your thoughts on this? I mean, as you mentioned at the outset, it would take a constitutional amendment to do it.
But what are constitutional amendments? They get passed only with you need a supermajority. It's just not going to happen,
Yeah.
because that's all this. I don't think it's going to happen. But historically, it has worked because at one point, and this may have been back in the, I'm not even going to say what years it was, but the Supreme Court ruled that income taxes were illegal, unconstitutional, and it was to benefit, big business. And so what do? I mean, pass the 16th Amendment. The 16th Amendment is what was the response. Yeah, we are going to have income taxes. So the constitutional amendments have been enacted when the Supreme Court has really not done what they should be doing. And it isn't just the 16th Amendment, the 17th Amendment, the 19th. So it is a way to do it. It's a safety valve on the conduct of the Supreme Court. But given today's polarization, given the fact that we need supermajority, I don't see it happening.
Danny, any thoughts along
Well,
this line?
I mean, I like the idea, and remember that we have a variation of that in California now, where after 12 years, a Supreme Court, and I guess appellate court judges, come up for reaffirmation.
It's retention elections.
And it's kind of a weird ballot thing, if you remember it. It says, should so-and-so be retained? Yes, no. It's not like they're running against anybody. It's just, right. Do you stay or go? But we have that, and it's that we haven't always liked how people voted on that, but it's not particularly a bad idea. And we certainly have had people sitting on the Supreme Court way beyond the time that they should have been, and were quite senile. Let's remember that Rehnquist used to sit on the bench and drool. That Hugo Black was senile before he was off. I mean, so there's a reason for removing people in that situation.
Closing thoughts in 20 seconds.
20 seconds?
30.
It's very, very important that when the courts, especially the Supreme Court, issues decisions, that we read them. We are in a rush all the time, and you hear stuff, we need to read them. And I'm going to leave you with a quote from Justice Souter. He said, "A principled decision is one in which the court candidly and convincingly explains why this principle prevailed over that principle. It is the choice of principles that is the tough part. The public judgment has got to be a judgment on whether they believe what the court says, whether they believe what the court says is convincing in making that choice between principles."
Gonna have let's go there. You can watching Other Voices, brought to you by Peninsula Peace and Justice Center. Thanks for joining us.
Thank you.
Thank you, Judge.